Court will call Boone County Case 2014-149 and 2014-154 and Newton County Case 2013-26, State of Arkansas versus Heather Carter. Item 14-149 originally was on Judge Putman's docket. He issued alias warrants back in the fall. Ms. Carter appeared on the 3rd of April and on that date was directed to reappear on the 24th of April, and then on the 24th of April this case was moved for an appearance on this date. I haven't as yet come across a transfer of this case to the Division 4 docket. Yes, it is. Here it is. So this case is on the Division 4 docket, as is 2014-154. And I don't see that we have this case on a scheduling, either of these cases on a scheduling order.
As the court may be aware, Ms. Carter was a fugitive for some 8 months or so.
In abundance of caution, I still like to try to stay within the 1 year if at all possible in terms of getting a case set and disposed of. So, what are our trial settings in July?
July 6th, the week of July 6th.
Okay. And now the Newton County case is this a revocation? I just don't remember. We have a Newton County trial date in July as well. Come on.
We can do it at the end of that week.
Set it down for the 9th of
9th and 10th.
9th and 10th of July.
Yes, sir.
All right, court's going to set the Newton County case for trial July 9th and 10th. It will set, let's see. I'm going to set these cases for pretrial hearings, all of these cases for pretrial hearings on June 5th.
Judge, with regard to the Newton County case, by my calculations, because of the various delays, et cetera, and excluding the time, speedy trial runs on the Newton County case on June 8th. So if we could have a earlier trial setting, that would work a bit better for the court, or for the state.
All right.
I think we would comply with the law.
I appreciate your figuring that out. Okay, we're going to what days do we have in June or before the 8th?
Before June 8th.
I'm sorry, what?
Before June 8th.
Yes.
That's correct. May 21st.
So the next date we have in Newton County is May 21st?
Yes, sir.
All right. It doesn't leave everybody much time.
Yes, sir.
Judge, we're going to, excuse me, we're going to need a pretrial date prior to the 21st in case there's any motions that need to be filed. Unless you want to hear it the morning of the 21st.
And that's what we may have to do. Because I don't have any dates.
Well, if there's any pretrial motions to be filed, I'll just assume we're going to hear it on the 21st.
That's a Thursday, isn't it?
Yes, sir.
Well, we'll set it there, and we're going to set it on the 21st. We'll take up pretrial motions if there are any, and then we'll pick a jury, take up pretrial motions, and then try the case is how we'll do it. And so. Now, on 2014-149 and 2014-154, I'm setting those cases for pretrial on, I think did I say June 5th?
Yes, sir.
On June 5th. Let me get this one. What, you said July 6th?
The week of July the 6th.
Right. Okay, those cases will be set during that, both those cases will be set for trial the week of July 6th. And pretrial on June 5th. All right. Any other matters to be taken up at this time?
Not by the defense.
All right. You may be excused. Thank you. Boone County case 2015-18, State of Arkansas versus Gerald Brewer. Mr. Brewer's case is set for trial the week of July 6th. The pretrial is scheduled for June 5th, and this date is the date for his reappearance to check on the status of the case.
Your Honor, we are on track with the scheduling order. The prosecutor and I have not formalized a plea offer just because some of the complexities of the case. However, we have been discussing that, working on it, and we're right on track with the scheduling order.
Okay. Is there anything that the court needs to either be aware of or needs to assist you all in getting this case ready for trial?
Your Honor, the court wanted pretrial motions filed by the defense by May 22nd. The state and the defense have discussed a potential pretrial motion that very well may require a hearing.
And Judge, that if we proceed as planned, we'll probably need to have that in chambers or in a closed courtroom.
Okay. Are we talking about a
Juvenile records, Your Honor.
Okay. All right.
We could probably discuss the issue with you in chambers ahead of time, and then decide, depending on what we work out, what we need to do.
Put it on the record, or if necessary, we can clear the courtroom. We'll do that on June 5th, potentially.
That'll work.
That's the pretrial date. All right. Mr. Brewer, you may be excused.
Plants, plants, and more plants. That's what you'll find at Camps Plants in Harrison. Perennials, annuals, ferns, hanging baskets, shrubs, roses, and the largest selection of garden vegetables in the area. With different varieties arriving weekly, you're sure to find the perfect plant, shrub, or tree at the best price in the area. Camps Plants, in business for over 30 years in Harrison.
Nature's Wonders has been the area's premier location for value and quality in vitamins and minerals since 1994. But that's only scratching the surface. Nature's Wonders also features products that are better for you and your family's everyday needs and are also better for the environment. Nature's Wonders' selection of freshly grown organic vegetables and environmentally safe cleaners allow for a healthier heart and home. From the latest addition to the trusted friend, there's something for everyone at Nature's Wonders, your supermarket of healthy choices.
2015-26, State of Arkansas versus Brian Mitchell. Once again, Mr. Mitchell's case is down for jury trial the week of July 6th and pretrial on June 5th. Where does this case stand?
Judge, I believe we're going to be ready for plea. Mr. Mitchell's been screened for drug court. Is that correct, Mr. Mitchell?
Yes, sir.
Your Honor, if we can have him brought over on the transport list later today.
All right. Court will direct that he'll be transported over. 2015-28, State of Arkansas versus Justin Ritter. This case, again, is for reappearance today. Check on the status of the case with the July 6th trial setting and a June 5th pretrial.
Your Honor, we've just received discovery in this matter as far as some DVDs, and we're on track with the scheduling order. I'm going to have a visit with my client out in the jail now that we've received the additional discovery.
All right. Well, Mr. Ritter, your next appearance in court will be for your pretrial on June 5th. In the meantime, you need to communicate with your attorney, and he'll be out to see you. 2015-71, State of Arkansas versus Dominic Bruns. This case is on the Division 4 docket, has been is down by scheduling order for trial the week of August 31st. Pretrial is set for August 14th. And we have a reappearance date on July 24th. I'm trying to remember why we have it on the docket for today.
Judge, I think it was just a reappearance to make sure the discovery and everything was proceeding. Dominic, you weren't able to get anybody to do a $3,000 signature bond?
No, there seemed to be a misunderstanding. It was supposed to be my mother signing me and to live with my mother. My father does not live in this county, let alone this state. He lives in Indiana, so if I would be able to be somehow over to her, that would be most appreciated, sir.
Okay, so you would be staying with your mother here in this county, correct?
Yes.
And your mother will sign a $3,000 signature bond?
Yes, she did so last week, but there was a misunderstanding due to the,
What's your mother's name?
Michelle Leslie.
Leslie?
Yes, L-E-S-L-E-Y.
Okay. Your Honor, I would just ask that the bond condition this court previously set just be modified to allow his mother to sign the $3,000 signature bond, along with the other terms and conditions that the court previously imposed.
Okay. And the conditions on that bond are that the defendant will live at home, be subject to residing at home, and not leave there except for the purpose of employment, and he needs to he'll need to keep the state informed of his employment and the hours of his employment. So,
Judge, that's the conditions you imposed on him earlier.
Dominic, once you get out, I'll get you to make an appointment with my office. Come see me.
All right.
so yeah, that's, excuse me, okay. This is the way we worded it the other day, was defendant will live with his father, is what we said. So it's supposed to be his mother?
Yes, Your Honor.
This is what's filed of record, so we need to correct that. He'll live with his mother under house arrest, and we had it with an ankle monitor, is what we had it the other day. So that
I think they would still put the ankle monitor on.
Okay. So I want him under house arrest with an ankle monitor and checking with the Boone County Sheriff's Office. No contact with the victim, no computer access, and seek employment or remain home. Not around any teenagers. All of those were conditions of this bond, and the only thing that changes is that he's be with his mother in place of his father.
Judge, with regard to the ankle monitor, I want to make it clear that if the ankle monitor indicates that he is not where he should be, that would be a violation of the conditions of bond.
That's bond, Judge. That's different than
I understand.
an illegal search and seizure. Can we get Travis to go out from the jail?
If he's going to go and go, I will get hold of that.
Okay.
Go out.
Dominic, we're going to see if we can get a hold of one of the officers to come out and put the ankle monitor on him.
today?
You'll need to contact your mom and have her come sign the signature bond.
All right.
All right.
And when will that be appointed? Will that, this afternoon?
This afternoon.
All right, thank you, sir.
Okay.
Next matter is Boone County Case 2011-2, State of Arkansas versus Tamra Eddings. This is a first appearance on a petition to revoke. Let's see. Court's making the appointment of the Public Defender's Office in this case. The petition to revoke was actually filed in January of 2013. It alleged
Judge, apparently there's been an updated one.
Judge, one I have appears to be filed on April 28, 2015.
the line? Okay. I see what happened. It's got stuck in a different place. All right. The petition to, the newest petition to revoke was filed April 28, 2015. And it alleges that the defendant is in violation of, for breaking the term and condition for not committing any violations of law. It's alleged that she was arrested on May 26th for domestic battery in the 3rd degree. It's alleging that she failed to report to her supervising officer on or about November 6th of 2014, and that she had not kept her fees, supervision fees, current, and as of October of 2014 was in arrears in the amount of $166. Those are the allegations contained in the petition. How does the defendant plead on these allegations?
Not true, Your Honor. We'd like to address the issue of bond.
Okay, I'm going to set her down for let's see, today's. I'm going to set her down for a revocation hearing on May 22nd, which will be the date of it, unless the court's for some reason still in trial on that matter in Newton County on the 22nd, but in which case we'll move it to the 5th. But it'll be set for hearing on the May 22nd.
Your Honor, my client was charged in district court. She's made bond on that charge in district court. She's entered a plea of not guilty. In this particular case, Your Honor, the other two matters of violations are things that occurred last year, and it's my understanding she hasn't failed to be reporting to an officer, and she's not in arrears. Because of that, Your Honor, my client, calling the court's attention, had a previous matter in front of the court. We had no issues. I represented her previously. She has a 1-year-old child. I'd ask the court to either release her on her own recognizance or allow the bond she posted in district court to stand in this matter as well.
Your Honor, this matter is a little different. The state asked that Tamara Eddings be held no bond. She is on probation, 5 years probation for domestic battery in the 2nd degree. The allegation is that she violated her terms and conditions by committing domestic battery in the 3rd degree. That alone should cause the court a great deal of hesitation. She would be in jail for at least 2 weeks with a prompt setting on her revocation hearing.
Who is the victim of her, alleged victim of her most recent allegation?
He's coming up on the docket, Your Honor, for his first appearance in revocation, Brandon Stewart, and he was charged with domestic battery as well.
So it's not any of the previous victims?
I don't believe so, Your Honor.
I think that's probably correct.
Judge, there's sufficient, especially the nature of the charges, there's specific safeguards the court can put in place. You can order my client not to have any contact with Mr. Stewart.
Who is taking care of the child at this point?
Grandpa is. Judge, if you want to think about this for a minute, I'm going to obviously have a conflict with the other first appearances coming up, and I'd ask the court to, if you want to take that one up and read what the allegations are in that petition to revoke before you make a decision on this. I think that might shed some light on it, Your Honor.
Well, there's a level of violence here, and I'm not sure how, even though none of the allegations relate to the child, to abuse of the child, there's just a level of violence here that the court has real concern for.
Judge, if you look at my client's the allegation, she was arrested on 526 for domestic battery. The quote alleged victim, who was also charged with domestic battery on 4/8, on 4/11 admitted to smoking marijuana. On 4/17 tested positive for amphetamine, benzodiazepines, and cannabinoids. Was arrear and supervision fees. To my client's credit, Your Honor, no alcohol, no drugs. My point would be bad taste in men. I don't think she should be held in jail without bond for bad taste in men. If that was the case, Judge, my wife had been in jail 31 years now.
Yes.
Flowers are on the way, huh?
I'm going to court's going to set bond. I'm going to set bond at I'm going to set bond at $10,000. It'll be conditioned upon her having no contact with any of her previous alleged victims, including the victims in the original case file, and certainly no contact with Mr. Stewart. Obviously, the court's concern is that this child that I presume that she will resume caretaking for will be back in her custody. The court has real concerns about what that child is going to be subjected to and whatever her living arrangements are. So I don't know how to exercise more control over what those living arrangements are, other than to just prevent them from being around circumstances that previously have resulted in various forms of violence. So that's what the court is trying to do. I'd like some reassurance of where she's going to be living with that child. Do we have any information about that?
If you make Bob, where are you going to be getting out and staying?
My mother's.
Okay.
It's in Bergman.
All right.
Isn't your mother one of your victims from the previous case?
No, sir. I don't believe so.
What's your mom's name?
Vicky Britt.
Okay. All right. Well, I'll approve that. The original information in this case, going back to 2010, cites her mother as Loretta Eddings, but obviously that may be a mother-in-law, so I don't know. But all right, I'll approve a bond as long as she resides with Miss Britt, and if that's where the child's going to be, then the court's going to provide that none of her previous victims or alleged victims, including Mr. Stewart, can be around her or the child, and will also, the court's going to provide that she's not to have anybody residing in the household who's using controlled substances for alcohol.
The judge said he's cash or pro.
Cash or pro.
Thank you. Cameron, your bond set at $10,000, cash or professional.
2012-182, State of Arkansas versus Brandon Stewart. This again is a first appearance on a petition to revoke. The petition to revoke was filed April 28th of 2015 and alleges the defendant has violated the law and has a domestic battery charge in the third degree in district court, alleges that the defendant used and admitted to using controlled substances in April of 2014, tested positive for amphetamines, benzodiazepine, and cannabinoids. Again, this was in April of 2015. Had failed to keep his fees current as of April 2014. Those are the allegations contained in the petition. On those allegations, how does the defendant now plead?
Denies the allegations.
I'm putting down a not true plea. He'll be set him for revocation hearing on April 22nd as well. May 22nd as well. Thank you.
Hi, this is Jim Fitzgerald of Community First Bank, and we have a variety of home loan options that are sure to fit your financial needs. From 100% financing rural development loans to VA loans for veterans to FHA loans with low down payment options, your locally owned hometown bank has the right home loan for you. Community First Bank, where it's all about community. Member FDIC and an equal housing lender.
Nature's Wonders has been the area's premier location for value and quality in vitamins and minerals since 1994. But that's only scratching the surface. Nature's Wonders also features products that are better for you and your family's everyday needs and are also better for the environment. Nature's Wonders selection of freshly grown organic vegetables and environmentally safe cleaners allow for a healthier heart and home. From the latest addition to the trusted friend, there's something for everyone at Nature's Wonders, your supermarket of healthy choices.
When you support a locally owned pharmacy, you're contributing to the growth of the community. The dollars you spend stay right here to support our local community. Health Mart pharmacies are locally owned pharmacies. There's one right here. Health Mart pharmacists have a personal commitment to their communities because, just like you, they support their community. Health Mart pharmacies are locally owned and hometown proud. Harrison is a Health Mart town. Sam Alexander Pharmacy on the square downtown. Health Mart, caring for you and about you.
Anything else? The defendant may be excused. (2013-172) State of Arkansas versus Bridget Varner.
Judge, we'll have to have Mrs. Varner placed on the transport list, be brought over.
Okay, is that for hearing this afternoon?
That's actually going to be for a plea.
All right. You'll be transported over. You may be excused at this point.
Thank you, Your Honor.
2014-29 State of Arkansas versus Diana Johnson. Ms. Johnson's down for a first appearance on a petition to revoke. Court is approving the Public Defender's Office to represent Ms. Johnson. The allegations contained in the petition to revoke are that on February 15th of 2015, she was arrested for drunk, insane, and disorderly. Is that really the charge? Drunk, insane, and disorderly, and assault on a household member in the third degree. Also, a violation of the requirement that she not consume alcohol. Also, a violation of failed to report in February after a release from incarceration. It's alleged also that during a home visit, it was discovered she didn't live in March. She didn't just live at the address that she had provided to probation and parole. Those are the allegations contained in the petition.
Your Honor, we'd enter a plea of not true, ask to have this set over for hearing on May 22nd. I'd also ask the court to release my client on her own recognizance. Ms. Johnson was my client when she pled on the original charge. She's had the same job for 5 years. I take exception to this because her previous officer was Bobby Hicks. She did report that change of address. She did report her release from incarceration, and I'd ask the court to take note of this offense occurred back in February, and after she reported it, after she has continued to pay fees, be on supervision, then this gets issued, a warrant gets issued for her arrest, and she's taken into custody. And for this much time to elapse before she gets taken in, and based upon these allegations, Your Honor, I plan on having Mr. Hicks here for the hearing, contrary to whoever the officer was that issued this report, to verify all that information. Based upon my client's track record of always appearing in court, she does have a good steady job, she does pay her fees, with the exception of this one incident where it's alleged she committed this offense. She's been a good probationer, and I think that she's not a flight risk, and I think she, in this particular case, Judge, she should be released on her own recognizance.
What says the state?
Judge, I never like anyone released on their own recognizance. State's not necessarily opposed to a small bond, but release someone on their own recognizance, they can just sort of leave the area, nobody's looking for them.
Judge, a condition of her bond can be she continues to report to probation and parole. She's been reporting. She continues to report. She works right up the street here, Judge, and has done so for the past 5 years. Judge, I would ask court to take notice of when these alleged violations occur and when it was filed and when she was arrested.
Yeah, I'm taking note of that. I always take note of that. That's not, and these are relatively recent allegations, so I don't consider them. Court's going to set bond at $1,500 cash or professional bond, and she'll be expected to maintain regular reporting with her probation officer.
Thank you, Your Honor.
Razor, Ranger, Sportsman, Ace. There's a Polaris to match your passion. Looking for a machine that works, hunts, and plays just as hard as you do? That's Ranger. Go ahead, tackle the toughest jobs, haul the biggest crews, bring home the best value. Ranger gives you the versatility to do it all.
You work hard to take care of your car, so help clean its engine and extend its life with quality gas from Conoco.
In the Branson area, visit these Conoco Phillips White Oak stations, plus Mule Express, Saddlebrook, and the Spirit Shop.
Liquidation Outlet in Harrison. What will you find today? Where everything is up to 50% off of retail. Hi, this is Amy, and we've got everything from entertainment centers and furniture to toys for the kids and baby supplies. We also carry bedding, luggage, humidifiers, and lots of craft items. With so many choices, you'll find the perfect deal for you. Stop paying retail and head to Liquidation Outlet for great savings. If you miss a day, you miss a great deal.
Best deals that you can get at the Liquidation Outlet.
Calling 2011-220. Joshua McEnany. Where do we have Larry?
Judge, with regard to Mr. McEnany, I was contacted yesterday by Mr. Pasting. I do not know if he's entered an appearance or not. Mr. Pasting discussed getting Mr. McEnany out on bond, and I told him that I am opposed to a bond until the misdemeanor assault charge is resolved.
This is let's start fresh. He does, as far as you know, at this time, he does not have an attorney. Mr. Pasting, he's contacted, or somebody's contacted Mr. Pasting?
Yeah, yes. Mr. McEnany's wife, who is also the alleged victim of the assault. She's also a probationer to this court.
Mr. McEnany, can you explain what the situation is with respect to your being represented by counsel?
Quite sure I understand, Judge.
Well, do you have an attorney? Are you represented by an attorney?
Yes, sir. I called my wife last night, and look, she's going to try to get Mr. Pasting in.
Okay.
I've been going through 2 or 3 months of trying to get my seizure medication leveled out, getting switching medication. It's a long, drawn-out thing in between switching from old to new. You have to come down off the old and decrease the old and increase the new steadily. That way, there's no adverse effects, and it's pretty tough on them. As far as going through neurological standpoint. Address to Mr. Carter there. I don't know if you have it in front of you, but my probation officer, I've had my filings are paid off for, I believe, 1.5 years or 2 years now. And been reporting who good is there, and I believe my next appearance for the misdemeanor is scheduled for July 27th or July 24th, somewhere there. I could be wrong, it might be in June, out for quite a while.
Well, I don't have those particular records in front of me. I have a record that
my daughter also had kidney surgery, reconstructive kidney surgery yesterday afternoon, and I haven't really been able to see her. I know she was asking for me when she woke up yesterday, and that's pretty tough to go to.
What's her name?
Harley McEnany. I believe we tried to contact you.
I was contacted, I believe, by your wife, but at the time I had no idea who you were or where you were. I mean, she just called me out of the blue directly, and I told her if I got some information, I would consider that along with other issues in the matter relevant to a release on bond. I have here on the desk this morning something that was transmitted to me by the officer Spencer in relation to a Harley Ray Neal.
Yes. That's what the Children's Hospital has run. But since then, I'm the only dad she's ever known. We've legally had her name changed to McEnany.
I see.
She's more kidney disease.
All right. Mr. Carter, you say you were contacted by Mr. Pasting?
That is correct, Your Honor. He contacted me yesterday afternoon.
Did he?
And I told him what my position was.
Did he make any indication whether he had actually been retained in this matter?
He indicated I am going to represent him. So
Okay.
I took that
All right.
he had been retained in some manner.
All right. On that basis, I'm going to reflect, let's see, I'm going to reflect Mr. Pasting as the attorney of record. This is a first appearance. The allegations are that on or about March 29th, 2015, Mr. McEnany was arrested on a charge of assault on a household member, third degree. I have no other information than that. You say it was his wife, the same person who contacted Mr. Pasting and now is allegedly contacted me by telephone. I don't know if it was her, but I would assume it was.
Judge, I do actually know a little bit about the facts of this case. Neither one requested charges against the other one. I believe this was a neighbor that called in because of all the commotion that the neighbor heard, and that led the police to go out there.
Well, I'm going to enter a plea if not true on Mr. McEnany's part at this time.
We also have a 9-month-old and another just turned 6-year-old that we adopted as a wife's sister. So since she walked back out there to the house, I was with all the kids.
I understand. Are you saying that you have your medicine issues under control?
Sir, I've gotten a lot better. I'm almost completely off my old medicine and starting to take full dosage this week. being here my new medicine.
Okay.
And that's,
Are you actually under the care of a doctor that you see regularly?
yes, sir. Dr. Kaplan, neurologist out of Fayetteville.
Okay. Who is taking care of your children at this time? Is your mother, your wife down with the child that's being operated on at Children's Hospital?
I'm not sure if she got to come home last night or what's going on this morning. I have to make a call yet.
Court will set bond. I'm going to set a bond. I'm going to set it at $1,500. That'll be cash or professional bond. It'll be conditioned upon Mr. McEnany upon his release residing at the household. I'm kind of against my general principles to send him back into the same household where this alleged assault took place, but under the circumstances, and because, as I say, I had some direct contact with with who Mr. Carter says was the victim of this assault, and it's quite clear to me that she very much wants Mr. McEnany out of jail, and didn't appear to me to be afraid or concerned about that. I'm going to provide that it's a condition he go back to the household and act responsibly in taking care of the children. I also want him to require him to stay on his medication and continue to control his health situation as a condition of bond. That'll be the order of the court.
Your Honor, to be fair, and so Mr. McEnany is aware, when I talked to Mr. Pasting last night, Mr. McEnany was not on our docket, and of course, when he was called, came as a surprise. I had actually assumed he was a Division III case, and so Mr. Pasting and I figured that he was going to be arraigned on the 15th. That's why Mr. Pasting is not here.
Okay.
Otherwise, he would have been here.
Well, I'll put him. I'm going to put him down for hearing on this matter on the 22nd of May.
Is able to verify with Sam. He will represent him, but he hasn't been paid.
Okay. Thank you. All right. You may be excused. Your next hearing in court will be May 22nd. If you make that bond, you need to be in court on May 22nd here, and you need to get in touch with your attorney, Mr. Pasting, as soon as possible, and make sure he understands where you stand. All right? You may be excused.
KTKO Channel 8 Harrison, local television.